Morning, Judge.
Hey, good morning.
Coming around this way, sir. Sir, this way for me.
Dr. Byrne took your advice and came in last night. Back to Sarasota. Stand over here right in the middle.
Okay.
There you go.
Morning, Dr. Byrne.
How are you, sir?
Thank you for coming.
Thank you for letting me come.
Yes, sir. Hey, guys, keep it down, will you, please? Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. Give the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Excuse me, Your Honor. Hold all conversations or take them to one of the witness rooms, please.
Officers were dispatched to a crash in Harris County, Texas. The wheel witness stated that he was towing a car when the defendant crossed into his lane and hit the car that was being towed. The defendant told officers that he drank 6 Bombay Sapphires and did not know he struck another vehicle. SFSTs were conducted, 6 out of 6 HGN, 8 out of 8 walk and turn. The officer did not ask the defendant to do the one-leg stand due to balance problems and age. DIC was read and breath consented, 0.139, 0.135.
Prior to WIs?
No, sir.
Okay. Mr. Byrne, I'm going to find that there's probable cause to go forward with the case. The only thing I'm ordering you to do is not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming any kind of alcohol or illegal drugs, I'll put you in jail. You will not get any more PR bonds. You've got a great lawyer helping you out. I will waive your appearance so you don't have to waste your time coming to court here, but you must stay in touch with Mr. Alford and he'll tell you when you have to come back to court. So you're welcome to go back to Florida if that's where you're going to go. But understand, if they call you for a drug test, you'll have to test at Quest Diagnostics, get the test to Mr. Alford, and that'll satisfy us. Okay. So just be careful. Don't pick up any new DWIs. Just, you know,
Probably not.
well,
You have any questions for the judge or anything I need to ask?
I don't know what to ask.
Good,
Thank
good. It's a
you.
good answer.
the only other thing I'm going to suggest to you is that it's very possible because this DWI, you might lose your license because of the administrative license case that you have versus DPS. So just stay in contact with Mr. Alford. If it does become suspended, you can't drive. In the event you do, you can always get an occupational, but just be wary of that. Okay,
Thank you, Judge. I've already requested a hearing.
great. We'll just have you sign a reset. We'll have you meet with pretrial and then you guys are good to go. Okay,
Thank you, Judge.
Thank you, sir.
happy travels. Ramon Sanchez, come up.
Is your turn?
Ricardo. So this is what we're going to do. We're going to wait for your lawyer to show up. Take a seat for me at the jury box. Don't go anywhere, sir. Good morning, ma'am.
Sir,
Ma'am, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. So you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On October 15th, 2024, officers conducted a traffic stop on the
All right, sorry, Mark.
Oh, okay. On October 15th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it fail to signal a lane change and swerve left and right within its lane before striking the curb. Officers observed the defendant to be the sole occupant of the motor vehicle and detected an odor of alcohol and bloodshot, watery eyes on the person. Defendant admitted to drinking. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, 3 out of 4 one-leg stand. DICs were read and defendant consented to breath test, 0.163, 0.161.
Where was this?
It was east on Clear Lake City Boulevard.
Okay, all right. Because I'll explain to you later. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol, any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand?
yes, sir.
Do you have a Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
I have regular insurance.
You have car insurance in
Yes,
your name?
sir.
Okay. We're going to reset your case to give you time to hire a lawyer. Don't sit and wait because you're only hurting yourself. You need to talk to a lawyer immediately because there's a lot of timing requirements. I'll have you sign a reset with Victoria. We'll have you meet with pretrial for your bond conditions, and after that, you're free to go.
Yes, sir.
Okay,
Thank you.
please.
All right, Judge, next is page 1, arms, come on up.
Oh, any prior DWIs on that other one?
Oh, no.
Good morning, Mr. Arms. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Defendant and the defendant are married, and on October 1st, 2024, officers were dispatched to a family assault in Harris County, Texas. Complaining witness and the defendant got into a verbal argument. The defendant stated he was going to take the car and leave. The defendant then pushed complaining witness against the car with both of his hands in her chest and neck area, causing pain. Complaining witness stated the defendant held her against the car for a few seconds and then let go and proceeded to leave. Officers observed redness on complaining witness' upper chest and lower neck and on her back.
Do you know?
I know that it's his wife.
She's here. If she wants to have, she's here. Contact with him or no? Don't say anything, Mr. Arms, please.
It looks like this is a DBD case. It looks like we haven't gotten the chance to reach out to her yet. I believe that the defendant is saying she's here in the courtroom right now.
Is there a Haley Arms here? Okay. Are you Haley Arms? Okay, just take a seat for me momentarily, ma'am. You want to reach out and see what she wishes? Mr. Arms, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any threatening or harassing contact with this person. If you violate these conditions, I'm going to put you in jail. You will not get any more PR bonds. I'm also ordering you not to be in possession of weapons as well. Do you understand?
Yes, sir, I do understand.
There is a protective order that has been in place. I would get to know it because if you violate this protective order, the state can and will file additional charges against you. And then things will really go sideways quick. Are you on probation or parole at this time?
No, sir.
Okay. So for now, what do you do for a living, sir?
I work for my wife, home health care.
Sorry?
Work for my wife, part-time home health care.
For your wife.
She owns a home health care service.
Okay. And what do you make a month?
Work like 6 days a month, about $285 a month.
Why not a regular job, 9 to 5 that every day?
Because of my criminal history, sir, I have a hard time finding a job.
The more you pick up, the worse it gets. How old are you, sir?
I'm 39, gonna be 40, sir.
39.
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. And I'm going to randomly test you. If I find that you're consuming alcohol and any kind of illegal drugs, likewise, I will put you in jail. I'll have you fill out an application. I need to know everything about you, how much money you make, how much money you have in the bank. And then I'll take a look to see whether you qualify for an appointed lawyer. But understand that you're under strict supervision now. I don't want any more issues. Otherwise, there's only one place. Do you understand?
Yes, sir.
Okay. Do you mind giving him an application? It's right here. This one, yeah. If you just give him one, we're going to give you an application. I'm going to have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box for now, sir. Do not leave, okay? All right. So don't worry about filing conditions because I'm going to make sure he's monitored.
Peyton, I'm here on Sydney Burrows. He has a bond violation with alcohol in his system. I'm not sure what date that was. I was trying to pull. Yeah, he understands he messed up. So he's here. The only thing that I can say to be proactive about what he's trying to do, I got his pretrial diversion packet together. He took a 4-hour drinking class on October 17th, and I have him set up for a TRAS. He had a theft back when he was a kid, like 18 or 19.
Come on, Mr. Burrows.
He had a theft when he was 18 or 19. They sent him to Wymack or one of those facilities. And
I'm not going to send you to WIMAC just for a simple.
yeah, back in the day it was.
Not just for
Trust, I researched it. No, I researched it, Judge. I'm telling you, it was in one of those courts. It was a long time ago. And I looked at everything and I thought the same thing. I mean, he can tell you.
Perhaps it was an ag rob pled down to a theft.
No,
Who knows?
it was not. It was an employee. There was an employee theft.
I was working at Office Depot, yes, sir.
Regardless, I ordered you not to consume alcohol. Just because you had a theft when you're 18 doesn't allow you to consume alcohol now when you have a DWI.
Yes, sir, I understand.
Now I'm going to put an ankle monitor on you so I know that you're not consuming. And the next time you do, you will go to jail. There's no excuse. I don't care what I don't care what you're telling me. I don't care if it's NyQuil, mouthwash, a tequila lollipop, hair dye. I've heard it all and I don't care.
Yes, sir, I understand.
Next time you will stay with me. Do you understand?
Yes, Your Honor.
This thing is extremely finicky and it detects alcohol through your perspiration. So be careful where you go, what you do, who you're with, because I won't entertain any more excuses. Do
Yes,
you
Your Honor.
understand?
Yes, Your Honor.
Take a seat, please, sir.
Yes, sir.
All right. No tolerance for Mike.
I was just saying that's why we have to apply.
Yep. Come up, Mr. Osborne. Guys, what is all the times that we've had Mr. Osborne tested, times that he's been positive, times that he's been negative? How many times have we tested Mr. Osborne, please? It's nearly 400 days old and he's continuing to smoke weed. I mean,
This is the first time he's actually been tested, to my knowledge.
I don't think that's right. I think that we've tested him before.
I understand he tested positive, Judge. My only concern is he is trying his degree and he's I mean, obviously, through his own doings, missed a lot of days of school, but I'm concerned that he's not.
Since December 21st of 23, he has had a dismissal offer where he's had to do 12 hours of community service, one class, and he gets his case dismissed. Now, a year later, we are still here and he's testing positive for marijuana.
Only number I had for him was his mother's number, which is why he initially, it got disconnected. I could not figure out how to contact him, which is why I had the PTI offer, but I couldn't reach him to give him the
It's
PTI.
not your fault, Mr. Schofield, and I'm not going to let you fall on the sword for him. But you're still smoking. Just the one today?
Yes.
We've never tested him before? Where are we going?
He signed the PTI yesterday, so he's just got to get his community service and his anger management done.
What kind of anger management class are we talking?
Our anger management class, and he has 12 hours of community service.
You have 3 weeks to get everything done. If you don't have everything done in 3 weeks, you will get an immediate trial setting. This offer goes away. Do you understand, Mr. Osborne?
Yes, sir.
And the next time you test positive, I'm going to light you up. No more weed. How old are you?
18.
No more weed. Do you understand?
Sir.
You will get tested again. And if I find that you're continuing to smoke weed, into jail you will go. You have 3 weeks to get this thing done. That's it.
That's 3-1, Judge.
What's the last name?
Tomas Gonzalez.
What page is it on? Did on docket today?
Yes.
Marcelino, okay. Mr. Marcelino Gonzalez, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor. You are facing a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand that by pleading guilty to this offense, it will go on your record. It's going to be there for the rest of your natural born life. If you ever get pulled over in a car and you have an alcohol on your breath and the officer sees that you have a prior DWI, what do you think they're going to do to you? Right.
Yes.
What we're doing today, you will now be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand? And if you are not in this country with permission, you go to jail for that time. I can all but guarantee that you will get an immigration detainer. So if you have people that depend on you for whatever purpose, you going to jail for that kind of time completely wastes them. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you cannot change this. It will go on your record. It will be there until the day you die. Do you understand?
Yes.
Do you still want to do this?
Yes.
How do you plead to the offense of driving while intoxicated? I will find you guilty, sentence you to the 3 days in jail, give you credit for the 1. I'm going to suspend your license for 90 days. Do not drive until you get a license. Otherwise, you will be right back over here. Are you appointed on the case? Good luck to you, Mr. Marcelino. Oh, it's 3,500. Good morning, Mr. Brooker.
Good morning, how are you? It's a criminal trespass charge.
Okay, Mr. Williams. So you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You guys, I guess, have worked out an agreement. They're offering you time served. This is what you want to do. You need to understand that it's going to go on your record from now on. You're facing a minimum of 30 days in jail for any new cases that you pick up. You also give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Is this what you want to do? How do you plead to the offense, sir? You high right now?
I don't believe he's intoxicated, Judge, at all.
How do you plead to the offense, sir?
Trespass.
Guilty, I'll find you guilty, send you to the agreement. I'll roll your court costs so you won't know anything.
Thank you, Judge.
Except for Mr. Williams. You know, you got the one life. All you're doing is you're racking up more and more charges. Sometimes you're going to see it's going to be really difficult to get a job, and it's already tough to be in your position now as it is. All you're doing is making life more difficult, man. Get on it.
Good morning, Judge.
Hey.
Fugitive case. I see Miss Tang in the courtroom. If they could bring Miss Rasul over, she's in custody.
Great. You seen, where's the trial? Where's Tyler?
Judge, he said he's on his way. He got caught in another court.
You here with the jury? Yep. Come on, man.
And Judge, Miss Rasul is the one that she had the 30-day pre-signed waiver. And then she signed the 14-day waiver. And then the state asked for a couple of extra days because she's going back to North Carolina. And we're just going to explain to her what's going on.
Amy, what was the last name again?
Russell, R-A-S-U-S, Katrina.
Good morning, Miss Russell. How are you?
Great.
So it looks like to me, you were wanted out of North Carolina, specifically Wake County for a felony probation violation, another probation violation, another probation violation, and a misdemeanor probation violation. So it looks like 3 felony probation violations and a misdemeanor probation violation. What's more is that you were on bond for a fraud case here. God, the bond was at nearly $500,000. It looks like that was just recently disposed of on the 7th of this month as well. Well, 180 days state jail, I guess, right? So Amy, what's going on now? So there's a pre-signed waiver.
Yeah, we already entered it on October 17th.
Got it. So a couple things you need to understand. Depending on where you get on probation, when you get on probation, especially on felony cases, you sign something it's called a pre-signed waiver. You sign a document saying, okay, look, by signing for this probation, I agree to waive formal extradition so that you can never fight extradition if you're ever picked up in another state, another county, or whatever. In that respect, even if I wanted to give you a bond, I can't because you've already waived extradition as it is. So I can't give you a bond. We typically just wait. And as a matter, it's 30 days that they have to come pick you up, not the normal 14, because it's a pre-signed waiver. At that point, it's a 30-day wait that we give them for North Carolina to come get you.
Well, I came in court today. I signed my waiver on the 16th. My day started on the 16th, the 14th. And they said they wanted extra 5 days, but my mama talked to my attorney. They said they're not coming to get me, sir. It's old, 7 years old. They're not coming.
Well, and if that's the case, then once the 30-day runs, at that point they'll issue a nollie, and then they'll get out of here.
On the 16th, my day started on the 16th. I'm aware that I signed my waiver, and they said that you signed off on it for extra 5 days. They said they asked for extra 5 days. My attorney.
It's still within the 30 days, though, right, Amy?
Yes.
It's still within the 30 days.
Yeah.
So it's still, I mean, we're not doing anything to you.
For the extra 5 days, they said that they want to come and get me. If they don't come and get me by what, November 4th, do y'all release me?
What's the date?
And they are scheduled for November.
So they've spoken to North Carolina. North Carolina is still interested in you, and they're indicating that they're going to come get you. So I don't know who your mom talked to, but they're talking to the sheriff's office and the DA over there, and they've indicated.
Can you tell me why it's on the 18th and my day started on the 16th? I signed with you on the 16th. Can you tell me that, please? I signed on the 16th, sir.
So the 16th was the original waiver.
Yeah.
That was the 14 days, but then we had to get an extension, which is why we entered the.
So it's 5 days from the 14th. That's what it is. No. Remember, it's a 30-day window that they have to come get you, not the 14th.
On the 16th. I didn't go to court on the 18th. I signed on the 16th. That's what I'm not understanding. I got the papers.
Okay. I mean, it's still within the 30 days. Okay. So they have up to 30 days. Sometimes they need a little bit more time. As long as it's within the 30 days, it's fine. It's not an issue. But they have up to 30 days to come get you. So I don't know what the actual day that they're going to come. I have no idea. So I'm not going to commit to an answer for you because I just don't know what day they're actually going to come. It's just that they have 30 days to come get you, and that's what's going to happen.
Talk to the prosecutor.
Don't talk to her.
So if November 5th, they don't come and get me, then what? I got to come back to court or what? That's what I want to know. I'm not
No,
understanding.
they have until the 16th of the following month. Theoretically, they have the 30 days to come get you. Now, we try to get them to come quicker, but sometimes they do, sometimes they don't. It depends on how many other people in other jurisdiction, other state that they have to come get. But they try to do everything at one time so they don't continue, because every time they come pick you up, it's $3,000 there, $4,000 there. So they try to do everything at one time to maximize spending, so they're not wasteful. When you get on probation, fulfill your probation, because when you don't, and when you end up with these violations, this is what happens.
I'm sorry, yeah. Thank you.
Right, ma'am, come on this way.
Wow, passive aggressive. Hey, we have a shuffle. Okay. Alex, Mr. Haddad, do you want to come talk about the slides? So you have an objection to one of their slides?
Yes, and
Okay.
Mr. Floyd has been texting me that he wants me to tell you that I am doing voir dire.
Okay, great. Good. Yeah, because we're gonna get started. I don't want to wait any longer. Jury's waiting. They've been here for at least 20 minutes, so. Okay, actually, let's get it. Everyone, we are going on the record. Do not talk. If you need to talk, if you want to go use your phone, go outside, but we're on the record. Please keep it quiet. Thank you, Roland. Okay, are you guys ready? We're gonna do announcements. All right, good morning, everybody. My name is David Fleischer. This is County Criminal Court at Law number 5. We are here with regards to cause number 2499983, State of Texas versus John Gerard O'Shaughnessy. Today is day set for trial. Guys, would you please announce yourselves for the record?
Michael Haddad for the state.
Alex Macias for the state.
Savannah Luna for Mr. O'Shaughnessy.
Okay. So first things first, it is 10/22/24, October 22nd. It's approximately 9:52 in the morning. We've started out this morning. Defense has requested a shuffle, so we're getting that into the works. It has also come to my attention, and I asked both parties yesterday, I think it was yesterday, if they had any pretrial or preliminary issues that they need to go over. At that time, they had indicated no. One thing has come up now. It looks like the state has a PowerPoint presentation that you're going to do for purposes of voir dire,
Yes, Judge.
but you have an objection.
Yes.
State your objection.
Yes, so, if you don't mind. So for slide number 5 of the state, it's called refusal to provide a specimen. While I understand that that is the law, however, they only cited part of Texas Transportation Code 724.015, A1 and A2. And I'm objecting because this is going to confuse the jury. It says that if the person refuses to submit to the taking of the specimen, the person's license to operate a motor vehicle will be automatically suspended for not less than 180 days.
All right.
However, okay, yes, and
It's just not right. So if you can take that out, at least that portion out. If we take that, are you okay with the rest?
well,
Yes.
also for 724.011A, they cited part of it. However, with respect to y'all, they did not cite the full statute. It just says driving in a public place.
Can you put the whole thing in
We're
there?
gonna delete the slide.
Yes, Judge. The slide will be
We're gonna
deleted.
entirely
Yes,
delete
Judge.
the slide.
And then if you go down a little bit, I had another one. And then they have what is now marked as slide number 8. In it, they put what I would say random, it says Texas County Court Statistics, January 24 to September 2024. And it's circling the total cases in the docket, total convictions, and total acquittals of, and I don't know where this is from, so I don't know how reliable this is. And second, it's going to inflame the jury because it says total convictions. And what it doesn't say is that if you look at dispositions by the jury, it's 376, and acquittals by the jury is 271. Instead of circling that, they have done a full list and tried to show total convictions of 80,603 versus acquittals by the court and jury of 367. That is not an accurate
Why do you
reflection.
have statistics up there?
In your honor, the main point of that statistic, just to demonstrate the nature of the justice system where there are convictions and there are acquittals, to demonstrate that the burden of proof is met throughout the state.
I mean, I don't think it's really.
In your honor, yes, that's the main purpose of that. It's from the Texas state.
Yeah, I think it can be misleading, and statistics can be manipulated in any way to show anything, and if you don't cite a source, we don't know where.
We'll delete the slide, Judge.
Okay.
Yes, Judge.
Anything else?
Yes, sorry.
This is a new one?
Yes.
Okay. We've got the news. She shuffled, so we've got the new one out. Thank you.
Yeah, I couldn't play that. It looks highly inflammatory to me.
I don't know if we can let the judge see it.
Talking about.
It's a burden of proof slide. Have you seen it? It shows a video clip. It's like some pirate or
Your Honor.
terrorist holding a knife like this, but I haven't been able to play the video, so I'm not really sure what it.
Can you show it to them real quick so they can see it?
You got creative coming up with all. This is all like off script, right? Put your work in.
The pertinent portion would be,
Does that have sound?
yes, it does. Let me,
Oh, it's Indiana Jones.
it's Indiana Jones.
Oh,
Who can object to Indiana
Indiana
Jones?
Jones, wrong. Come on, it's my hero.
It was like, what happened to him or something like that?
Correct. It's just,
Is that what you're gonna ask? Like,
correct. Can you tell despite not seeing?
that's
that?
fine. I
Yeah.
can't object.
Mhm. Okay.
Harrison Ford.
Anything
Okay.
else?
Were there-
He deleted the punishment.
And I will delete those statistics on there.
The only other thing I would put on the record is, I understand Mr. Macias is practicing under a supervised bar card. And he was gracious enough to send us that letter. Ms. Luna was the same, and I looked up the rules about what they can do. And some judges didn't think she was able to do. It is from the state bar, and it says that you must be practicing under a supervised attorney, but they actually list Ryan Free. So supervising attorneys, and it says Ryan Free. And that's the only attorney that the state bar lists can be supervising him
It can be supervising Alex.
on his supervised status letter from the state bar.
He's another chief judge.
So we looked at this heavily. We had a long conversation with Judge Wright. There is a provision for remote, just to be completely candid, for remote supervision. And I actually called the state bar about that, and Miss Luna was in here trying to obtain a reset. I was across the hall, and they said there's no problem with that. And she can contact you by text, she can call you. It's not a hearing. So that was remote supervision. But for me to not sit with her during a trial, you can't remotely supervise them throughout the entire trial. They'd have to like be on the phone with you the whole time.
So you're
on Zoom.
objecting to his presence then?
Yes.
So,
I don't think it allows for him to try a case. Just going by the letter, it says specifically Ryan Free. It's the only attorney listed as the supervising attorney.
So Floyd, can you do me a favor? The statute that allows Alex to practice under a supervised attorney, does the wording state that as long as there is a supervising attorney, or is it only the person that signed their bar card?
Show me what you have so I can see it.
It's not a statute. It's in the
Yes,
disciplinary
my
rule.
apologies, yes.
The Harris County DA's office.
And with respect to everyone here, and I don't mean to be rude,
Judges,
it also has to be someone that's been practicing for at least 3 years to supervise him.
Do you want me to email this to all the parties?
Yeah, or show me what you're referencing.
So what did you type to?
I typed in Texas student bar card and it says supervisor.
So then it might be that you might have to try the case, Mr. Haddad, and then Alex sits kind of, second chair with you. Tyler, you might have to try it against Mr. Haddad.
Alex is way too prepared, so. No,
Careful what you wish for, as they say.
I mean, I just think it's an issue that everybody should be aware of.
And I mean, if you're right, then you're right. I don't know. I've not seen the rule, and I didn't know what his actual status was until now. Then you just said. So.
And so these are called the rules governing the supervised practice of law by qualified law students and qualified unlicensed law students, law school graduates in Texas. And then if you go to rule.
Alex, are you still in law school now?
Yes, Your Honor.
What year are you?
A third year.
And if you go to Rule 4, it says, subject to the approval of the presiding judge, administrative officer, arbitrator, or other hearing officer, they can appear in any trial, hearing, arbitration, or proceeding on behalf of a client, provided the qualified law student or qualified unlicensed law school graduate has obtained the client's consent, notifies or has previously notified the court of the client's consent, and is accompanied, whether in person or by remote means, by the supervising attorney. And then if you go to rule.
But there's no client in this respect.
Yes,
Right.
but
I mean,
yes. And then the second part was about that was rule 6, and this is rule 7. I struggle with Roman.
Do you have an email?
Because, well, the spirit of that is with respect to if you're actually representing an individual person as opposed to the state.
Yes, Your Honor, I was just, if you go down to Rule 7
Okay,
for supervising attorneys, the supervising attorney has to be an active member of the State Bar of Texas in good standing who has practiced law in Texas for at least 3 years. So
has he not practiced law?
I have no,
And
and
Your
that's what I
Honor-
was asking, if he, if
How long have you been
No,
practicing?
two, Judge, but I'm just reading, I'm reading some of the rule.
There's a duty to immediately notify the state bar membership department if the lawyer no longer meets those requirements of these rules. If you give me your email, or did you already find it? You tell me?
It's here.
It's David underscore, right?
Let's see. Yeah, first name first and then last name underscore last name at CCL. Yeah, it's okay.
I understand.
No one's going to do anything. Do you want to reach out to Beadle and see what he says real
Can you
quick?
give me one moment?
Of course. Take your time. Just not too long because we got the jury, but yeah. Josh, send it to me real quick, will you, Tyler, and then I'll take a look.
Just sit down.
No, you can stay there, but I want to thin out the line. Josh, what you got? Tell me, what you got?
Yes, sir. First is Roberto Castro.
Wait, we got him? Is he back there?
So he's not, so it's a different guy. It's not
Not the same.
Not the same Davis guy. Yeah, that was Justin Davis. Sorry, it's on Roberto Castro. Okay. Yes, sir. So I've been on the
It
phone
is
with
the
him.
Roberto Castro that I'm talking about. Yeah.
Oh, it might be a different one. Okay.
No. Roberto Castro.
So
He made bond.
he was on mine when I was appointed. Yeah. I think we're mixing it up with Justin Davis was the other one that.
No. I know Roberto Castro, long hair.
Right.
I've known him for a very long time.
Yes, sir.
I like him, but
Right. Yes, sir. So I've been on the phone with him pretty much all morning. He was trying to get on a bus in the Heights, and I've been kind of tracking. He's been trying to get here, but is having trouble getting transportation here.
okay.
But I was gonna see if we could roll to tomorrow. I
Yes,
think
Josh,
But I'm in contact. He should be here.
I trust you. Okay.
And then I also had Daniel Jones in custody, and I believe we're still we're waiting for the 911 and the RIP call. This one.
Yeah, it's still kind of early, Josh. And do you want to set it for one day after the felony?
We'll make sure we have all those things done.
Yeah. Remember, it's a jail case, so we're going to kind of move more expeditiously. Yeah. Is that it?
That's all.
Today.
Yes, sir, Your Honor. Your Honor, I am here on Mr. Raphael Jar or Milo. I spoke with Ms. Victoria, and she informed me this case is 250 days. He's been in abscondment for the past 8 months, Judge.
Is he in jail?
Yes, sir, he's in jail. He got picked up the other night for failure to ID, and picked up a failure to ID, but prior to that, he had 2 cases of DWI and an unlawful carrying a weapon that occurred sometime back in January. So he's been an absconder for that period of time. I've had a conversation with him this morning. I told him that the videos on the first 2 cases should be available because it's been 9 months ago. And he wants to go on and proceed so he can get back to his country. He understands that.
He wants to plea.
He wants to plea.
He has a felony case out of the same transaction at the DWI. Did you see that?
No, sir, I did not.
So he has a less than a gram case upstairs as well, out of the same transaction of the DWI. So it looks like he picked up a UCW, DWI, and a less than a gram on January 1st. I guess went on the lam. He now picked up a failure to ID. If he wants to, I'm certainly okay with it, but let him know that it could hurt the felony case as well. The felony case is set for November 4th. So if you want to, we can do the day after.
The day after 4th. Yes, sir.
Whatever you want.
Yes, sir. Thanks, Judge.
Hey?
I need to go to the doctor. I don't know.
What happened?
I was, it buckled. I was carrying something heavy.
Say that again?
It buckled on me when I was carrying something heavy up the stairs.
Oh, I'm sorry. I hurt my back if it's any consolation. It hurts like a. Okay. Hunter, let's get you out of here. What do you got?
Yeah, I have Williams, Calvin.
You know, you can always zoom in too.
Oh, I know. Yeah.
Zoom in so you don't
But I
have.
was already here, so
Williams?
yeah. And my client was here, so I wanted to be here.
Okay.
Judge, I still need to negotiate with the state, and also he still needs to pay me some. So I was just trying to get a reset.
Okay. I'll give you one more.
Okay.
Gotta be at the next setting though. That's it.
Sounds good, Judge. 30 would be perfect.
Done. After that, but that's it.
Yeah.
Okay.
Thank you, Judge.
Judge, can we approach O'Shaughnessy briefly?
Okay.
So, Judge, I've spoken to Ryan. He's willing to swap courts with me for the trial so Alex can try this case.
Okay.
So I'm gonna go to court 11. Ryan's gonna come here. This case is gonna be tried with Alex. Okay.
Okay, there you go.
Do you, Tyler, do you have any objection to that on the record?
No.
Ryan coming? Okay, sounds good.
Sorry.
We'll get that done. No
You
problem.
don't have to apologize. Just do what you do.
Page 38.
Thanks. Come on up, sir. All right, you are Samuel Smith. Mr. Smith, you're wanted out of the state of Louisiana, particularly St. Landry Parish, for possession of methamphetamine and cocaine. You waiving formal extradition, right? Okay, you need to understand that even though you have waived extradition today, the 14 days doesn't start ticking until you take care of your case upstairs, until you either plead to that case or you make bond on that case. While you have not made bond on it, the 14 days is told, meaning it doesn't start ticking until you either take care of it or you make bond. Do you understand? Do you have any questions? Are you waiving formal extradition, sir?
Yes, sir.
Okay, good luck to you, Mr. Smith. I need, if you don't mind, one more. Who's your guy, Alan? Okay, please. All right. Okay, guys, we're going to bring a jury in. If you guys can please clear in, ma'am in the pink, would you mind taking to the side, please? Guys, Mr. Terrell must come back after the drug test. Robert.
Judge, how are you doing, sir?
Hey, how are you?
Very good. I got a Jose Gonzalez Guerra on your docket. I know it's under Gonzalez, I don't know it's under Guerra.
Okay, we'll give you a reset, huh?
Yeah, please, Judge. We're still working on discovery on this one.
Yeah, for sure.
Thank you.
Hold on a second, let me get your date.
Okay. Any Tuesday or Wednesday, Judge, is fine.
All right, November 26th.
November
That's not
26th?
Is that Thanksgiving week, Victoria?
Yes, yes, it is.
Yeah.
I got my kids. I won't be able to go that week. I can do the week before or the week after. That's fine.
The 19th?
Yes. Perfect.
Done.
Thank you. Thank you. Bye.
Okay, have fun, man. Good morning, Mr. Abraham. Mr. Abraham, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 9 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. You now will be facing a minimum of 90 days in jail for any new cases that you pick up. You also need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point that will hit you with a felony offense, and then you're looking at years instead of days. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change this or undo this. Is this what you want to do?
Sir.
How do you plead to the offense? Guilty or not guilty? How do you plead to the offense of theft? Guilty or not guilty?
Guilty, but I didn't take that much $2,000 worth for anything.
No. What is a theft? You're charged with theft. I'll be giving you the range of punishment.
Oh, okay.
Okay, so you've worked out a deal, 3 days in jail, credit for the 9 days. What is it? Is it a Walmart? Their problem also compounding this is you will not be getting out today because you have picked up an unauthorized use of a motor vehicle. Your bond is set at $10,000. So until you make that bond, you're kind of stuck in there.
I'm seeing Timberwood Shopping Center. I know there's a specs there, but I think it's like a shopping mall, so.
That's where the theft is from.
Yes,
Okay,
sir.
is it true or untrue? Okay, we wish you the best of luck. All right, okay, Stephen, thanks. All right.
All heard are accounted for, Your Honor.
All right, thank you, Mr. Gaza. Guys, please be seated. Good morning, everybody. Good morning, everybody.
Good morning.
All right, my name is David Fleischer. Welcome to County Criminal Court at Law Number 5. We are but one of 16 misdemeanor courts here in Harris County. We have two different types of courts here, actually 3, maybe 4. We have misdemeanor courts, and then we have felony courts. What is the difference? Well, I'm going to give you a brief history lesson here. We have 2 types of charges in Harris County. I'm sorry, in Texas. I keep forgetting that it's Texas, but yeah. So we have misdemeanors and then we have felonies. What's the difference? Well, it's the amount of time that you're facing on any type of criminal charge. Where you're facing a year and under, that is a misdemeanor. When you're facing a year and over, that is a felony offense. Here, we only handle misdemeanors and then only certain types of misdemeanors. So we have 22 district courts that handle the felonies. They're typically in the higher floors. And then we have down here the misdemeanor courts. Around the city, we have different type of misdemeanor courts, but those are, they handle Class C type offenses, speeding, no insurance. Believe it or not, there's a Class C assault, harmful or offensive touching. That is classified as a Class C assault. Class C offenses are only punishable by up to a $500 fine. Here in this type of misdemeanor court, you can be facing for one misdemeanor charge up to 6 months in jail and or a $2,000 fine. And on the other misdemeanor, which is the higher, the Class A misdemeanors, you're facing up to a year in jail and or a $4,000 fine. So there are three types of misdemeanors: A, B, and C. C are the traffic ticket, municipal court, justice of the peace type cases. And then B and C are here's what we handle here in downtown: Class B and Class A. Class A are the more serious versus the Class B, which is the mid-tier level type of offense. Depending on where you go in the city, depending on what type of charge you pick up, if you pick up a speeding out there in Kima, you might get hit by or you might go to a justice of the peace. Remember that Harris County is so big, it will take you 2 hours to 2.5 hours, maybe 3 hours to get from one part of the city to the other part of the city, to the other part, depending on traffic. So because we're so large and we're so populous, we need more than just a municipal court. And so that's why they have justice of the peace all over the county. But when it comes to the more serious offenses, everybody comes here to downtown. Thank you so much for coming today. We really, really appreciate you coming and showing up for jury service. Houston has around 3 million to about 4 million people in our glorious city. And believe it or not, around 5 to 10% of the people who are called upon for jury selection actually show up. It's an absolutely abysmal number that actually show up. And it's really sad because this is what makes our criminal justice system operate. We, as a society, cannot function without you. If you didn't come, it would be chaos. And the thing about it is we're not asking you to split the atom, do Pythagoras theorem, any kind of quantum mechanics. All we're asking you to do is use common sense. What is happening today is we are having a trial today, and the trial is a DWI. You're going to hear evidence. You're going to see evidence. You're going to hear people speak. And all I'm asking you to do at the end of the day is just use common sense. When you hear someone testifying, you know in your gut whether they speak truth, whether they know what they're talking about, or if they're in outer space. You will know it when you hear it. Each of you have life experience, have been through things in your lives, so you know when someone is fibbing, telling the truth, trying to make it up as they go along. And that's what we're asking you to do. Use your common sense, use your instinct. Nothing serves you better. They're going to ask you all types of questions to see, hey, are you a good person? Are you a bad person to sit on this jury? What kind of experiences have you had with DWIs? Is it going to impact you? Guys, we need you. We need you just to, any kind of experience you have, I know that it may be hard, but we're not interested in that. All we want you to do, listen, look at the evidence, hear the testimony, and just make a decision. That's all we're asking you to do. This trial will last for 2 days, today and then tomorrow. Is there anyone that cannot be here tomorrow for any reason? They have, surgery, plane tickets, any reason someone can't be here. Please, please, please let us know now. It doesn't matter. I don't want you to get impaneled on the jury and then 5 o'clock or 4 o'clock today or tomorrow, you say, oh, you know what? I can't be here anyways. I got something to do. Please, by show of hand, do you have some kind of serious obligation that you can't be here other than you just don't want to be here? Juror number 2. Okay. And you're leaving tomorrow? Okay. Anyone else? You're juror 11, 12, 13, 14. Is that right? 15. Okay. Say that again.
I would like to go to New York tomorrow morning. I'm working there as a physician.